morning, Council. My name is Octavia Winfrey. I'll be your court reporter for today in Judge Richardson's courtroom. I'm going to call the calendar. Could you please let me know if you want your case taken down or not? The first one I have, and we may not have everyone. If we don't, we'll wait till they show up. I have National Collegiate versus Catricia St. LaFleur.
Sharice Teddy for plaintiff, and I do not need takedown.
Okay. The second one is Mount Sinai Wellness versus Scott Gillespie.
Jeff Nickerson for the plaintiff. I do not need takedown.
Benjamin Pierman for the defendant, and I don't need takedown either.
Okay, thank you. The next one I have is MPage Housing Group versus Collier Global.
John David Huffman here on behalf of the defendant and counterclaim plaintiff. If the other party's not here, we also don't need a takedown.
Okay, we'll wait till that one comes up then. Hertz Corporation versus Annie Scott. No answer. We'll wait on that one. First Acceptance versus Quantisha Davis.
Keisha Townsend here for the plaintiff. We do not need takedown.
Brand Vaughn Lumber versus Travis Stanley.
Good morning, Matthew Donahue for the plaintiff. The plaintiff is present, going to be a witness, but we do not need it taken down.
Thank you. Matthew, again, what is your last name?
Donahue, D-O-N-A-H-U-E.
Thank you. Crown Asset versus Adria Bell.
Judy Nam on behalf of the plaintiff. We also do not need a takedown.
Thank you. And my last one is Velocity Investments versus Jamal Totten.
Judy Nam again for the plaintiff, and we also do not need a takedown on this one as well.
Okay, well, I'll wait until the judge comes on, and if he doesn't need anything, I'll see if I can be excused. Thank you.
Thank you.
All right, good morning, everyone.
Good morning, Your Honor.
Morning.
Good
Morning,
morning.
Judge Richardson.
Morning, Your Honor.
Judge Richardson, I've made a call of the calendar and no one needs me unless there's a particular record you want taken down. And I can hang out as long as you need me to. But for the first one, I have like 3 no's. I have one that's going to be, I did not get an answer on, and that's position number 4. The Hertz Corporation versus Annie Scott.
I don't think we're going to get an answer on that one. We're going to let you go.
Well, thank you, Judge Richardson. Have a good day.
All right. I think I did hear the call of cases, so I'm just going to go through them in order. I think let me go out of order for a second. Position 2, Mount Sinai Wellness Center versus Gillette.
Morning, Your Honor. Jeff Nickerson for the plaintiff.
Morning, Your Honor. Ben Pierman for the defendant.
All right, I have this one down as ready for trial. Are y'all prepared to proceed with evidence today?
Your Honor, after speaking with Mr. Nickerson and with your staff attorney, Mr. Townsend, and I appreciate their time, I understand that we're down ready for trial on this calendar. I am asking for a continuance today. I'll go into that as much or as little as you'd like for right now.
Yeah, just tell me if you can tell me the short version of what's going on.
Yes, sir. The short version is that I received the notice of the trial calendar. Not being familiar with state court proceedings, I'll plead ignorance on that. I don't do any state court work except for this case. I thought that this was a status conference. I did not read the thing quickly enough or carefully enough, excuse me. And it is a very serious error on my part. And after speaking with Mr. Townsend and Mr. Nickerson was very great, very gracious and not opposing my continuance. Now, I understand that that is, of course, with Your Honor's purview as to whether or not we go forward today, but I am essentially asking for lenience from the court to allow us a continuance. I'm not ready for trial. In fact, I couldn't even contact my client. Once I discovered my error yesterday, I made efforts to contact him and was not able to do so. So I'm just to say that I was mortified and embarrassed yesterday and today is an understatement, but it is the situation that the defense is in, Your Honor.
All right, and plaintiff's counsel, Mr. Nickerson.
We have no objection to a continuance, Your Honor, there, but for the grace of God, go I.
Mr. Nickerson, that is a great display of professionalism on your part, and I can't let that display of professionalism go for naught. So I will grant one continuance, go to the next trial calendar. Have you all had a chance to have any discussions about possibly resolving this?
No, Your Honor, we haven't yet, but I can assure you that that is certainly something that we will be exploring in the coming days and weeks. Certainly, we believe that this case, there's certainly a possibility for a settlement where the parties can reach an agreement outside of court, hopefully, and I hope Mr. Nickerson agrees with that.
Always willing to talk settlement, and I have found this client to be reasonable.
All right, very good. We'll set it to the next non-jury trial calendar. Hopefully y'all can resolve it in the meantime, but the next time it's up, we'll be ready to go.
I greatly appreciate it, Your Honor, and I greatly appreciate Mr. Nickerson's forbearance on this.
All right, yeah, y'all both may be excused.
Thank you.
Thank you, Judge.
Let me call also number 4, Hertz Corporation versus Annie Scott. No answer on that one. Let me call position 6. That is Brand Vaughn Lumber Company versus Travis Stanley.
Good morning, Your Honor. Matthew Donahue for the plaintiff. A representative from Brand Vaughn Lumber is present to testify if Your Honor wants to take testimony.
All right, we have no one here for the defendant. All right, so I saw the motion and it has an affidavit. So unless he's testifying, your witness is testifying to something different or additional to the affidavit, I think I'm perfectly fine with relying on the affidavit for proof of the damages.
That would be fine with us, Your Honor. One of the areas of testimony that I had intended to get into was the personal guarantee. The Travis Stanley signed the commercial credit application as the personal guarantor. That document was attached to our motion for default judgment as Exhibit A1. So I don't know if this court, Your Honor, would like to take testimony as to that or just rely on the exhibit as it was attached.
I'll rely on the exhibit as it was attached. I don't think I need testimony that's sufficiently reliable. I have a proposed order. It does not include the calculation of attorney's fees. So let's talk about the attorney's fees portion of what you're requesting.
Yes, Your Honor.
It's the proposed judgment says both 13-111 and 13-611. So can you get a little bit more specificity on what you're relying on? I think if you go 13-111, you'll get 15% and you don't have to prove anything. But if you go 13-611, I'm going to have to hear testimony from you and some documentation as to what the attorney fees are.
I believe it should be just the 13-111. The reasonable attorney's fees at I think it's 15%. Take out the first 500, 15% of that. So I believe that's the calculation.
All right. So I'm going to grant the judgment as requested in the amount of $14,195.83 in principal, 18% interest through March 24th in the amount of $623.06. interest and attorney fees pursuant to 13-111. And I'll rely on you to do that calculation.
Okay, I think, yeah, I believe that we did put the actual number in. I'm trying to get to it, Your Honor.
And that's is that calculated on the 15%?
Yes, yeah, the attorney's fees of 2,222.83, I believe is calculated at the 15%. What I can do if the court would like is I can redo the calculation, and if it turns out that it's a different number that is higher, I can certainly submit a new order to the court if the court would like.
We'll check it from here. I've got your proposal.
Okay.
We'll take a quick look at it. Make sure that it's right. If not, we'll adjust it. And then we'll go ahead and get it entered.
Okay.
If you have no further business, then you and your witness may be excused.
Thank you, Your Honor. Have a wonderful day.
Thank you, Your Honor.
Bye.
Look at all right, let's go back to number 1, National Collegiate Student Loan Trust versus Floor.
Good morning, Your Honor. Sharice Teddy for plaintiff.
Good morning, Your Honor. This is Katricia St. Fleur, the defendant.
All right. So we're here because some years ago, our chief judge entered a standing order saying cases involving the National Collegiate Student Loan Trust, and slowly but surely, the Student Loan Trust has been making motions to lift some of those, the stay on some of those cases so that we can proceed forward with the case. So since you are here, Ms. St. Fleur, I'm going to allow plaintiff's counsel to go ahead with their presentation, and then we'll see if you have any response to it, Ms. St. Fleur. You're entitled to respond.
Okay.
Okay, so this is a motion to lift the stay, the CFPB stay, Your Honor. And we did file a response back in 2018 to the court order. So the court does have that. And basically, the arguments are that the CFPB order related to the collection of certain student loan debts, this particular account is outside the scope of that by way of a couple points. Number one, the CFPB court order, which again, all of these were attached as exhibits. Anything that I referenced orally would have been attached as exhibits to my original response. No affidavit was filed in the matter, in this particular matter. Obviously the CFPB, if you read that order, you can see that it had to do with cases where affidavits had been filed with the suit. In addition, a copy of the signed promissory note was included with the suit that we filed. The cases that were issued before the CFPB did not have promissory notes attached to it. In addition, in the final portion of the motion, and I'll just go through it briefly, is that we do believe that every document that was attached to the complaint, in fact, proves the debt, including the promissory note, all of the assignment and pool supplement documents, as well as any of the transaction histories showing the activity on the account. It's based on that argument, as well as my exhibits and my written motion, that the court, that the plaintiff is asking the court lift the stay and allow us to proceed with a pending motion for summary disposition. The motion for summary disposition would have been filed back in December, actually on December 26th of 2017, a day before the court actually entered the stay order. And our request for judgment on that, I don't believe it's before the court today, but to be asking for failure to respond to discovery request, specifically request to admit.
All right, Ms. St. Fleur, you have any questions or you have any response to that? I know that's kind of a mouthful and you may not have a full understanding if you haven't read the papers as to why we're in this position.
Well, I guess my response may not be directly related to the motion, but I did look over the documents, and I do have questions as far as my original response was that this was past the statute of limitations for Georgia, and I also disputed the amount. So as far as the statute of limitations, they said that my last payment was November 2009. I have no recollection of that. And so I was asking for proof of that last payment because I don't recall making that payment. I also received 1099s from JP Morgan Chase, which was the original servicer for the loan, discharging some of these loans. So I had multiple loans, but I don't know which ones were discharged. So how do I know that this is the correct amount that they're saying that I owe? So I haven't received any proof of any of that information, just the original prom note that was provided in the motion, the response to the motion, and that was it.
All right, so where we are today is St. Fleur, and what you're talking about sounds like arguments on sort of the merits of the case, whether they actually have a good case against you for funds. What we're talking about today is whether the case can go forward at all or whether it should remain in a holding pattern. I think based on what Ms. Today has filed and the arguments that she's made, I believe that the circumstances of this case place it outside the cases which were intended to be stayed by our court's standing order. So I am going to grant the motion lifting stay. I think we're going to have to set a hearing on, we have don't think I see any other motions.
Your Honor, we had a motion for summary filed. It would be, it was filed on 2/26 of 2017. That was a motion for summary based on failure to respond to request to admit.
Yeah, I'm looking at my docket.
Yes.
It is not showing on my docket.
Well, I would be happy to refile it with the original stamp up on the top right and re-e-file it for you so that you can view it, or I can send it to a law clerk, whatever you'd prefer, Your Honor.
Refile it if you would, so we can make sure we have it on record. I know that we've gone through a transition.
Yes. And it's been quite a while, so no problem, Your Honor. We'll get that filed by the end of the day. And as far as the order on the motion to lift stay, can we also file that by end of day today, the proposed order, or will the court be preparing its own?
Yes, you can. We appreciate a proposed order on that.
I will get both of those documents filed by end of day today, Your Honor, and that's my only matter, if I may be excused.
Ms. Today, you know, it sounds like there's some questions that Ms. St. Fleur has that perhaps if you're able to answer or give her some more information that might lead to a resolution of this. Are you willing to have a discussion offline with Ms. St. Fleur about this?
Absolutely. If she wants to provide me an email address or a phone number, I'll be happy to contact her regarding settlement and provide her with documents and whatever we want, whatever we can do to get it resolved.
Okay.
You want to give me your email address?
It's my first name, the number 6
Wait a minute.
@gmail.com.
Your first name. Can you spell it for me, just so I'm clear?
It's CATRESHA HA
Uh-huh.
6@gmail.com.
And your phone number?
It's 678-462-7279.
All right, Ms. St. Fleur, we'll be reaching out to you, okay?
Okay, thank you.
Thank you, ma'am.
Well, just be on the lookout for notice in the future. You know, they're going to be filing a motion, and just be on the lookout for that and notice of a hearing on that. But obviously, if y'all can work something out in the meantime, you know, I'd be glad to hear that and consider that resolution as well.
Okay, thank you, Your Honor.
Do you have any other questions for me, Ms. St. Fleur?
I do not.
All right, thank you. You may be excused.
Thank you.
Thank you, Your Honor.
Thank you. All right, let's go to M-Page Housing Group versus Collier Global.
Good morning, Your Honor. I'm John David Huffman here on behalf of the defendant / counterclaim plaintiffs.
All right, Mr. Huffman, I've read the papers on this case. This is a very interesting case.
Well, yeah, I guess if they had filed answers and stuff, we might have been able to litigate it out. But as a reminder, you probably know since you just looked at it, but there's a pending motion to strike, and then there's a pending motion for default against the motion to strike is against the original plaintiff, M-Page Housing Group, and then the motion for default is against the other three counterclaim defendants, which Your Honor added. It's been just about 2 years ago that they were added, and so we're prepared to have a hearing on damages as to all the defendants. And the motion to strike, we requested the court also strike the defenses to our counterclaim against M-Page Housing as well.
All right, that motion is granted, and I'm prepared. If you're prepared to prove damages today, I'm prepared to hear them.
Okay, we are prepared, Your Honor. I have Ms. Collier here on the Zoom with me. She is both a counterclaim plaintiff as well as a representative of Collier Global Georgia. And I'm going to do this as quickly as I can. And then if you want more information, Your Honor, I just ask that you jump in. But just very briefly, the counterclaim defendants, these two individuals and their two companies, run a real estate scheme whereby they put on seminars across the country and get new and unsuspecting investors to invest with them, and then they steal their money. My client was one of those investors, a new person into real estate investing. She met these individuals in California when they put on the seminar out there, and then through a series of lies through these individuals, she bought 2 properties in Atlanta, which they steered her to buy, making a lot of misrepresentations along the way, including the fact that they owned the property that they sold to her, which was she did not know at the time she bought it. Afterwards, she funded around $30,000 before she really discovered the con to them, which they made off with. And then she took over the projects herself and lost a lot more money at that point. So the damages that we intend to show are as follows. She bought a property on 1135 Sim Street in Atlanta, whereby she lost $43,000. The second property she bought was on 204 Rhodesia, where she lost $74,000. And she had to spend a lot of time and other compensatory damages. So I'm happy just to swear her in and walk you through it real quick if you'd like. All right.
Yes, go right ahead.
All right, Ms. Collier, could you please raise your right hand? Do you swear or affirm the testimony you're about to give this court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I will.
Okay. You just heard my synopsis of the case. Is that true and correct?
Yes.
Okay, and did you buy 2 properties in Atlanta?
Yes,
All right, and what was the first one that you purchased?
1135 Sims Street, and
Okay,
the second one 204 Rhodesia Avenue.
all right. And Your Honor, is it possible for me just to share my screen? I think you probably have to allow me to do it. All right,
You should be able to do that now.
all right, thank you. All right, very briefly, Ms. Collier, is this the document that you have created to show your damages on these 2 properties?
Yes,
All right. And so on Sim Street, what was your actual hard loss on it at the end of the day?
it's about 43,000.
All right, Your Honor, you can see basically she started briefly with her purchase price and then she ran through the expenses minus what she was able to sell it for at the end right here to arrive at this 42,990.29. And then scrolling down here on Rhodesia, did you do the same thing, Ms. Collier, on Rhodesia?
Yes,
All right, and what was your loss on that property?
it's around 74,000.
Okay. And did the counterclaim defendants represent to you that these would be a passive investment for you?
Yes,
All right, and did it turn out to be a passive investment for you?
no,
Okay. In fact, you flew out here several times and had to hire your own contractors and manage them after they took off with the original money, correct?
yes,
All right. And about how many hours did you spend trying to rescue this investment that you made?
approximately 1,000 hour.
Okay. And you currently work a job making about $37 an hour, is that correct?
Yes,
All right. And so, Your Honor, we're asking for that time that was sold as a passive is $37,000. And the money that you, let me see, I'm going to stop sharing my screen here, Your Honor. I'm happy to provide that document to the court if you'd like.
Yeah, put it back up. I had a couple of questions.
Okay, sure.
Before we do that. Right, Ms. Collier,
yes,
you prepared this document?
yes,
All right, so is there some place where you keep records that reflect all of these totals that are kept on this document?
yes, I have that one, the original and Excel spreadsheet.
And so this is something that you've compiled over time from records that you have at home?
Yes, from the time I purchased Sims.
All right. And who is Bruce Bishop?
He was another construction guy when O'Brien Ford bailed my construction. He came to the rescue for Sims and Rhodesia so we can sell the properties.
Okay. And I see something in here on the second property about a citation and fines of court costs. Tell me about that.
Yes, Mr. Ford Construction, basically after he received the money from me, he just did touch up construction, but he put all of the trash outside the house. And when the police came by and gave me the citation, since I am in California, I cannot do the court in Georgia. So I hired Mr. Guillemette to represent me at the court. But he did remove all the trash and everything.
Who's another associate at our firm, Your Honor? Mr. Guillemette is another associate here.
Gotcha. Okay. Hey, you can take that down.
All right. And Ms. Collier, did you have to borrow and make some pretty hard decisions in order to fund and rescue these projects after they took off with your money?
Yes, with all the, I need to took money from 401k, my retirement, withdrawn some of my stocks, sold my car to compensate or to pay all of the construction so we can move on with the construction, and then sold the properties.
You asked the court to compensate you for that?
Yes,
Okay. And are you asking for $100,000 in sort of lost opportunity and stress and other damages associated with this from that?
yes.
All right. All right, Your Honor, very quickly, we're also asking for our attorney's fees in this case. And we're asking for our attorney's fees across 3 different matters. And I'll explain that very quickly. The first one you've already touched on, which was a housing code violation by the city of Atlanta that had to be dealt with, that was the cause of the defendants. The second one was actually an ex parte petition that we filed in Fulton County Superior Court to get the lien canceled that Mr. Page filed in front of Judge Ellerby. And then the third is this case and all the expenses arising from it. Those 3 matters total $24,917.50. And it was about 16 hours of partner time, about 49 hours of associate time, and 29 hours of paralegal time. I was the lead partner on all of those matters, and either directly did the work or supervised all the work involved in it. And then we had expenses that totaled $36.85.90. And additionally, Your Honor, due to the fraud and just the outright theft, the breach of fiduciary duty, and the partnership and everything, my client is also asking for $250,000 in punitive damages against the parties, and for all the damages to be joint and several, whatever the court awards.
All right, you have, can you supply for the record fee statements, billing statements to support the attorney's fees?
I'd be happy to, yeah, the invoices, sure.
Yes. I'm prepared to grant judgment in the amount of the lost economic damages that have been presented today. I think Ms. Collier is also entitled to damages for the number of hours that she spent. I may cut some of those hours down. I know it was a labor, but I may cut some of those hours down, but I'm prepared to award it at her rate 30, I think it was $37 an hour, Ms. Collier?
Yes.
And what is your occupation? What was your occupation at the time?
I still work in the office.
And what do you do?
I'm a senior research associate.
And in what sort of field are you a senior research associate?
I'm helping the broker in the Bay Area posting their listing on our database.
A broker?
Yes.
Like real estate?
Commercial.
Commercial real estate?
Commercial brokerage, yeah, in the Bay Area.
Is that like a real estate brokerage, an investment brokerage?
Just real estate. We are not a broker. We just a company that posting their listing on our database. Kind of like when you want to look to buy something, but we don't deal with any of their money or anything. Just posting the listing.
All right. And is your compensation, when you say $37 an hour, is sort of a salary breakdown, or are you paid hourly?
Hourly.
All right. And you've worked full-time in that position?
Yes.
All right. So I am going to compensate you for some. I haven't decided how many yet. I don't think it's going to be 1,000. I'm going to compensate you for time spent dealing with this issue. Lost opportunity, I think, is just too vague and speculative. I'm not going to award on that. I think this is certainly a case for punitive damages and attorney's fees. So I will award some amount for punitive damages and attorney's fees. If you would, counsel, if you would send a proposed order in judgment, one that takes care of the motion to strike and the final judgment, put in the amounts that you request and send it to Mr. Townsend in Word form. And I will make any changes that I need to make to it.
I thank you, Your Honor. Just so the order will grant both the motion to strike and the motion for default judgment, both of those motions. Okay. All right. And then I'll fill it out and then I guess you can make any changes. All right. Thank you very much. And do you want me to upload? I'm sorry, about the attorney's fees. Do you want me to upload those in an affidavit format or?
That would be best so that the record, if anybody's looking at this afterwards, they can see the basis. They can see the basis in the record for your attorney's fees claim since we don't have the basis on record here today.
All right, I'll be happy to do that. Thank you, Your Honor. Have a good day.
Thank you, Mr. Hoffman. Thank you, Ms. Collier.
Thank you.
All right. Let's go to position 5 is First Acceptance versus Quantisha Davis.
Good morning, Your Honor. Keisha Townsend here for the plaintiff.
All
My
right.
witness, Jared Ralph, is here.
Good morning, Your Honor.
All right, morning. So this case is in default. So I'm ready to hear your proof of damages.
All right, Your Honor, would you like me to swear in the witness?
Yes, you may.
All right, could you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, could you please state your name?
Jared Ralph,
Mr. Ralph, where are you employed?
First Acceptance Insurance Company,
And what is your job title at First Acceptance?
the subrogation specialist.
Do you have training and experience in determining when a vehicle is repaired versus a total loss?
Yes, ma'am, I do.
And do you have the training experience in determining the reasonable cost to repair a vehicle?
Yes, ma'am, I do.
Have you had the opportunity to review the damages incurred to Ms. Sconier's vehicle as a result of the collision with Ms. Davis?
Yes, ma'am.
What was the date of loss?
February 2nd, 2017.
And what kind of vehicle was Ms. Sconier's driving?
A 2016 Chrysler 200.
And was the vehicle repaired or was it a total loss?
It was repaired.
And what was the total amount of damages, repairs to the vehicle?
$4,698.08.
And does that total include the insured's deductible?
Yes, ma'am, it does.
So what was the total amount paid in damages for her vehicle?
That same amount, $4,698.08.
And was that reasonable in your opinion?
Absolutely.
Your Honor, we are asking for a judgment stay in the amount of $4,698.08.
Right.
I think we already submitted a proposed order, but if you'd like me to send one to Mr. Townsend, then I will.
All right, I have a final judgment proposed here. It also has a blank for attorney's fees. Are you prepared to request attorney's fees?
Your Honor, we'll waive it.
All right. The judgment's in the amount of $4698.08, principal plus all costs of court and post-judgment interest.
Thank you, Your Honor.
That judgment now. All right, if you have no further business, you may be excused.
All right,
Thank you,
thank you,
Your
Your
Honor.
Honor. Have a great one.
All right. Position 7, Crown Asset Management versus Adria Bell.
Good morning, Your Honor. Judy Nom on behalf of Crown Asset Management.
All right, so I have a motion for default. It's in the default status. Are you prepared to prove damages?
Your Honor, we weren't able to file our business record affidavit. We've been having some issues with our client, with them being in and out of the office. We were wondering if we could request a continuance for 10 days to file it.
10 days?
Yes, Your Honor, we will have it filed within 10 days.
All right, we'll give you 10 days on the affidavit.
Thank you so much, Your Honor. That's the same announcement for the next case as well. I represent Velocity Investments.
All right, 10 days for an affidavit.
Yes. Thank you so much, Your Honor. We will have that filed within 10 days.
All right. Thank you, Ms. Nam. You may be excused.
Thank you. Have a great rest of your day.
You too. All right. We are done. Judge Ross, good to see you. Come on.